Thank you, Mariah. The final pending bill on the legislative agenda is SB 630 by Senator Dodd, which begins on page 88 of your packet. This bill would require CSLB licensees to provide an email to CSLB at the time of initial licensure and renewal and update the email address within 30 days of a change. This bill would protect email address confidentiality by establishing that licensee email addresses are exempt from disclosure under the California Public Records Act. Finally, this bill would codify and standardize the registrar's authorization to revoke a license for failing to comply with probationary conditions. Fauna, would you please be so kind as to provide an update on SB 630?
Yes, so this CSLB sponsored bill was also discussed at the March board meeting, and the board voted to support this bill. Like SB 601, this bill was heard on Tuesday by the Assembly Committee on Business and Professions and unanimously passed. It has also gone through the legislative process without receiving a no vote so far. SB 630 is scheduled for hearing in the Assembly Committee on Judiciary next Tuesday, June 27th. Because this bill has not been amended, the support position previously taken stands, and this is only presented as an update. So I'll turn it back to Legislative Chair Galarza.
Thank you, Fauna, for that clarification. Since, again, as stated in the March board meeting, the board supported this, there is no additional amendments, and so there is no motion is required at this time. Nevertheless, are there any board members with comments?
I have a question. Does this mean, and I looked through this and I didn't see it, does this mean their email address will be displayed on the website, on our website? That would be
no. Sorry, the language of this bill would protect licensee email addresses from disclosure.
Thank
you. Remote comments from board members? Rico, are there any public comments?
No public comment.
Thank you, Rico. We'll now go on to our next agenda item, which is E3, review, discussion, and possible action item on amendments to business and professional codes, section 7071.4, to address board exposure to risk of liability for attorney's fees in legislation involving a deposit in lieu of bond. Carton versus RE Design and Construction. Based on a decision in Carton versus RE Design and Construction, CSLB would be exposed to financial liabilities for attorney's fees in all future cash deposit civil cases. The board was recently named as a co-defendant in a consumer versus contractor civil suit involving a deposit of lieu of bond. In this case, the CSLB is liable for more than $100,000 in attorney's fees. To address this recent development, staff are proposing amendments to the Business and Professional Code, section 7071.4. The proposal would clarify that CSLB should not be responsible for attorney's fees in this case. Fauna, would you be so kind as to provide an update on and a background on this item?
Thank you. Business and Professions Code section 7071.4 allows licensees who do not wish to file a bond acquired through a surety to make a deposit with CSLB in lieu of the bond. Subdivision G of that same section prohibits payment from any bond alternative filed with a registrar to be released unless as determined by the court. So in other words, we need a court order in order to make payment on that bond. In those cases, CSLB would be named as a co-defendant. In circumstances where instead of a bond, the contractor makes a deposit with CSLB, the law treats CSLB as a surety. So in the Carton case, this was a civil dispute between a consumer and a contractor. The court found the surety was liable for attorney fees. This case set the precedent that sureties, and in the case of cash deposits, that would be CSLB, the sureties may be responsible for paying attorney fees. Currently, CSLB is named in a case where we could be responsible for hundreds of thousands of dollars in attorney fees in a $25,000 bond case, where we were just, as required by law, waiting for the judgment so we could release the bond. So this legislative proposal would ensure CSLB is not responsible for legal fees associated with any civil action where a cash deposit in lieu of bond is made. Staff are requesting the approval to share this proposal with members of the legislature to seek an author. If it's too late to find an author, staff then request approval to include this proposal as a new issue in the sunset report. And I'll turn it back to Legislative Chair Galarza.
If I may add, this is John Kinn. If I may add to Fauna's comments, the appellate court ruled that in that case that a party who aggressively defended rather than released should be slapped, and they were slapped hard. And there's no allegation that CSLB has done anything in any of these cases other than the right thing, which is come into court as they are sued. And there is a new procedure now that CSLB has advised and have been accepted by the DAGs who are representing us in these cases, where we're nominal defendants sitting there with a small bag of cash, that cash by court procedure be as soon as possible at the first opportunity deposited with the court by a court determination under the statute of 7071.4. And I've seen one of those motions already and it's been successful. So hopefully the exposure will be limited, but in addition to this subsection that it prohibits us as a board from charging any money against those, the money we're holding on deposit in lieu of bond. Why not add a section that caps our liability at the amount of the bond?
Thank you.
Sorry, Fauna.
No, I appreciate the addition. Thank you.
Thank you both. So therefore, the staff is recommending a support on this item. Do we have a motion from the board?
Johnny Simpson, I'd make that motion.
Thank you,
Second.
Johnny. Is there a second?
Second.
Thank you, David. Are there any board members in the room that'd like to make comment on this item? Go ahead.
Do we have an idea of how many cash deposits we have percentage-wise versus bonds in place for licenses?
I believe Mike pulled data. Mike, do you remember how many we have?
We have to scroll through the data to get a perfect number because they all have different statutory retention time periods. Long story short, there are many, but statistically over the years, only about 10 of these get to court and get pled. So as far as our liability, our exposure for this Carton case, it might be about 10 cases a year. There are a lot of cash deposits still on file. Some contractors never got rid of them. They disappeared, they expired. We're trying to, it's very complicated, but our liability is only about 10 cases a year.
Thank you.
Any other members with comments? Remote members? Rico, are there anyone in the public that would like to make comment on this item?
No public comment.
Thank you, Rico. Mariah, would you be so kind?
Mary Tykert,
Aye.
Rodney Kobos,
Aye.
David De La Torre,
Aye.
Miguel Galarza,
Aye.
Amanda Gallo,
Aye.
Alan Guy,
Aye.
Susan Granzella,
Aye.
Jacob Lopez,
Aye.
Diana Love,
Aye.
Michael Mark,
Aye.
Stephen Pinelli, approved absence, Jim Ruane,
Aye.
Johnny Simpson,
Aye.
motion passes.
Thank you, Mariah. We'll now move on to section E4, regulations. Staff has two regulations to present. The first of those is agenda item E.4A, review and discussion and possible action on Sprinkler Fitters Association of California petition pursuant to Government's Code section 1134.0.6 and 1134.007 to amend section 832.16 of Title 16, Division 8, Article 3 of the California Code of Regulations, C-16 Fire Protection Contractors Classification, to include firefighter air replenishment systems, which begins on page 99 of your booklet. This will be received a petition for the adoption of regulations dated on May 11th, 2023 from the Sprinkler Fitters Association of California, which can be found on pages 102 and 103 of your booklet. The petition requests an amendment to the California Code of Regulations, section 832.16, which describes the scope of C-16 fire protection contractation. The petition would add FARs installations to work that would be performed under C-16 classification. Council John Klin would present the details, items concerning this petition. John, feel free.
Thank you, Chair Galarza. The petition letter and the applicable design and tech of Appendix L, as it's referred to in your packet, are in the packet. The board received this petition letter under the Administrative Procedures Act, asking for additional language in the classification of C-16 fire protection contractors, without really an explanation other than that the language is not currently in any regulation with the CCR. The petition process to amend a regulation under the APA is an extraordinarily rare event for the board. And so my explanation is unfortunately a little longer than I would prefer, but I'll go as fast as I can. The board looks to this petition letter to uncover a rationale or effect of the proposed amendment. And in the petition process, the board hasn't undertaken the usual reaching out to contractors and other classifications who perform this FARS work, such as the C-36 plumbing contractors. Nor has the board had a chance to thoroughly scour building officials for comments and the effect of this proposed language. So I'll start with the petition itself. It references the International Fire Code in this Appendix L, which is on pages 104 and 105, the design and install requirements for FAWs. The petition it correctly states that there's no current regulation language that defines who may install or repair FARs in California. The petition concludes that the most qualified to install piping and system components in FARs is the class of C-16 fire protection contractors. It's important to note that C-36 plumbing contractor classification performs work which is generally described by the FARS technology. The petition goes on to state that the Office of the State Fire Marshal has not adopted this Appendix L statewide, but that certain local jurisdictions have. However, state fire marshal regulations do not identify any CSLB license classification to perform this work. And classification determination, as you all know, is solely within the authority of CSLB. Other than describing the technology and stating that Appendix L is codified in some building codes and not others, the petition doesn't address why the amendments to this regulation are warranted. The petition does not provide evidence of the necessity for the proposed amendment, despite having opportunities to do so. Again, petitions to amend are extremely rare. Regulations must be approved by the Office of Administrative Law under the APA standards and procedures. As a good practice under the APA, agencies typically begin the regular rulemaking process with a concept, and the agency then encourages stakeholders to participate, to discuss, and clearly outline the need or rationale for a proposed action. This process will ensure and does ensure that mandates and standards of the APA are met and will be met by any proposal from the board. This is the preferred and most common method, as it allows the board to work out any issues before initiating an official rulemaking process. The petition process being used in this case does not include any of these usual preparations. And the petition under the Administrative Procedure Act must include three things. One is the substance of the regulation, the reason for the request, and the reference to our authority as a board to take action. The APA also provides this agency with the authority to either grant or deny the petition in whole or in part based on the merits of the information received in the letter petition. Government Code Section 11340.7, which concludes this petition process, also provides a means for interested parties to request reconsideration of any board decision, and the request must contain reasons why the board should reconsider the initial decision, and the agency should make a decision based on the merits of the request. The board in the letter petition does not have all the information showing the necessity, benefits, or consequences to the other classifications set forth in regulation. The petition presented in this case does not provide evidence or any explanation for how the proposal would benefit and protect the public, which is, as we all know, is of the highest priority for this board. Staff has recommended a denial of the petition on the merits submitted in this brief letter, and denial of the petition will not prevent the board from considering this subject on future agenda items or on future dates. So
Thank you, John.
Chair, are you going to go through the two options under the statute?
These two?
Yes.
Yes,
I can, yeah, I'll summarize it again.
Please
Thank you,
do.
John.
those are the two options for a motion from the board.
So as John stated, there are two options, and the first option is the staff recommends to deny the petition received from the Sprinkler Fitters Association of California dated May 11th, 2023, requesting to amend the CCR section 832.16 in whole is made based on the merits of the petition according with the Administrative Procedure Act. The information contained in the petition does not demonstrate or provide substantial evidence that the proposal is warranted. Such information supporting the petition be received. The board may reconsider in discussion with the stakeholders and public discussion at future board meetings. There appears to be some piece that I'm missing.
No, you're okay. That's just the staff recommendation from the bottom
Yes.
of page 101, but there are a couple options that the board can consider. I don't know if I see that in this.
It appears like that. Okay, thank you. All right, I'm back on track. Option one, if the board agrees with staff recommendations to deny the petitions as presented in the meeting materials, the board may take the following actions. Deny the petition based on the grounds set forth in the meeting materials and other grounds raised at the meeting, and transmit the denial to the Office of Administrative Law within 30 days. That is option one. Option two is if the board approves the petition and considers the proposal text acceptable as presented in the meeting materials, the board may take the following actions. Grant the petition, approve the proposed regulations text and changes to section 832.16 as provided in the material, and direct staff to submit all approved text to the director of the Department of Consumer Affairs and Business, Consumer Services, and Housing Agencies for review. If no adverse comments are received, authorize register to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the packet, and schedule the matter for public hearing. If no adverse comments are received within 45-day comment period or at the hearing, authorize the register to take all steps necessary to complete the rulemaking and adopt the proposed amendments to section 832.16 as noted. We have two options. Given that, I believe we would want to take a motion for option one.
I make a motion to adopt the staff recommendation.
Do I have a second?
Second.
Thank you, Johnny. With that, are there any comments on taking staff's recommendation? Remote comments? Rico, are there any public comments?
No public comment.
This is Rodney Cobos.
Hey, Ronnie, go ahead.
Yeah, can you repeat the option again?
The long one or the short one?
The short one.
Option one? All right. If the board agrees with staff's recommendation to deny the petition as presented in the meeting materials, the board may take the following actions. Deny the petition based on the grounds set forth in the meeting material and other grounds raised at the meeting, and transmit the denial to the Office of the Administrative Law within 30 days. That is option one.
Thank you.
Thank you, Ronnie.
Does that answer your question, Board Member Jim? I'm sorry, Rodney Cobos?
Yeah, so option, just so I can be clear, on option two, it allows the petition to come back if they provide more information.
No, option two is to approve the petition as presented and immediately send to rulemaking.
Which we don't have any supporting documentation for. That's what option two would be.
Understood. Thank you.
And my understanding is there's nothing that would preclude the petitioner from getting a better case together and coming back again.
Thank you, Mary. That's what I was trying to get to. Thank you.
Sorry about that. I didn't realize it turned that off. Are there any further comments?
We do have public comment.
Is there a public comment? Rico?
Yes, Richard Markison, I just sent you a request to unmute. You have 3 minutes to speak.
Good afternoon, board members. I'm Richard Markison, speaking to you today on behalf of the Plumbing, Heating, Cooling Contractors of California and the California chapters of the American Fire Sprinkler Association. Without commenting on the substance of the proposal, we would certainly support the staff recommendation, and both organizations would certainly commit to working with both the Sprinkler Fitters Association and with CSLB staff to better understand the proposal and would work with all interested parties in the event they decided to move forward with this proposal. Thank you very much.
Thank you. Rico, any other further comments? Public.
No further public comment.
Thank you, Rico. With that, Mariah, would you please call roll?
Mary Teichert,
Aye.
Rodney Cobos,
Aye.
David De La Torre,
Aye.
Miguel Galarza,
Aye.
Amanda Gallo,
Aye.
Alan Guy,
Aye.
Susan Granzella,
Aye.
Jacob Lopez,
Aye.
Diana Love,
Aye.
Michael Mark,
Aye.
Stephen Pinelli, approved absence, Jim Ruane,
Aye.
Johnny Simpson.
Aye.
Motion passes.
Thank you, Mariah. The final legislative agenda item is item E4.B, review and discussion and possible action on section 100 rulemaking proposal to raise the fine maximus to conform to Business and Professional Code section 7099.2. And that begins on page 106 of your pamphlet. In this item, staff requests board approval to engage in the rulemaking process to make non-substantive regulatory changes. The proposal would amend California Code Regulations section 88.4 to raise the maximum civil penalties for certain violations of the contractor state license law. I would refer to Fauna to provide additional information on this proposal.
Thank you. Business and Professions Code Section 7110 establishes that a contractor's willful or deliberate disregard for state and local building permit laws is a violation of the contractor's state license law. Last year, Assembly Bill 1747 by Assemblymember Quirk added Section 7110 to the list of violations for which a maximum penalty can be up to $30,000. Staff are requesting authorization to initiate the rulemaking process to amend Title 16, Section 884 in our regulations, which sets fines. These changes would conform to 1747 by updating the maximum fine amounts through the Section 100 process. So proposals made under the Section 100 rule allows amendments to be made without being subject to the notice and 45-day public comment period, as required by substantive rulemakings in the Administrative Procedure Act. This rulemaking would be considered technical, non-substantive, and without regulatory effect, as it would make Section 884 in our regulations consistent with the amendment statute. Happy to answer any questions.
Thank you, Fauna. Is there a motion?
Make the motion, Michael Mark.
Michael?
I'll
Thank you.
second.
And Mary Taggart, second.
Susan, yeah.
So noted. Are there any members on the board that would like to make additional comments on this item? Remote members?
I hate to do this to everybody, but we're going to read the elongated staff recommendation and then see if there's an emotion to adopt the staff recommendation.
Reading on. And it goes as follows. The staff recommendation is to approve the proposed regulation text for CCR Section 88.4, authorizing the register to take all steps necessary to pursue the rulemaking through the CCR Section 100 procedure. The authorized staff to make non-substantive changes to the text and/or rulemaking package as needed through the process. Alternatively, if deemed necessary by the Department of Consumer Affairs or the Business, Consumer Services, and Housing Agency, initiate the rulemaking process, making any non-substantive changes to the text and/or rulemaking package as needed through the process, and if approved by the Department of Consumer Affairs and the Business, Consumer Services, and Housing Agencies, set the matter for the hearing if preferred or requested. If no adverse comments are received during the 45-day comment period, authorize the register to adopt the proposed regulations to CCR Section 88.4 as filed with the Office of Administrative Law for the public notice and take all steps necessary to complete the rulemaking process, making any non-substantive changes to the text and/or rulemaking package as needed throughout the process. With that, are there any other comments from the public or from the board?
Is there a motion to adopt that staff recommendation?
Motion to adopt the staff recommendation as presented. Michael Mark. Second.
With that, Rico, one last time for the public.
No public comment?
Thank you. Mariah, would you be so kind as to call roll?
Mary Tykert,
Aye.
Rodney Cobos,
Aye.
David De La Torre,
Aye.
Miguel Galarza,
Aye.
Amanda Gallo,
Aye.
Alan Guy,
Aye.
Susan Granzella,
Aye.
Jacob Lopez,
Aye.
Diana Love,
Aye.
Michael Mark,
Aye.
Stephen Pinelli, approved absence, Jim Ruane,
Aye.
Johnny Simpson,
Aye.
motion passes.
And with that, we conclude the legislative regulatory agenda for today, and it is my pleasure to turn the meeting back to Chair Tygart.
Thank you very much, Board Member Galarza. That was outstanding and thorough. And also, we are going to take a 15-minute break and reconvene at 3:45.
Absolutely. That was a long week.
That went a little long.
Yep, that's okay. Okay, if we can take our seats again. Okay, if I can ask everyone to take your seats, we are at the time we said we would have for the break. Is the WebEx back online?
We are online.
Okay, outstanding. So we'll resume the meeting today with item F, enforcement. And leading us through that section of our meeting is going to be Enforcement Committee Chair Michael Mark. So I will turn it over to Michael.
Thank you, Chair Tykert. Good afternoon, everyone. My name is Michael Mark. I'm the Enforcement Committee Chair. I would like to begin with an update on the status of the Enforcement Division's strategic objectives established for the 2022-2024 CSLB strategic plan, which begins on page 114 of your packet. I will briefly review each item that requires updates since our last meeting, but invite any questions at any time on items that I do not cover or for which anyone has any questions. So starting off on page 114, strategic plan item 2.1 reads as follows. Leverage current enforcement tools to increase licensees and business knowledge by requiring contractors subject to CSLB corrective action to take specific courses. An update regarding the bill relating to CSLB authority to require specific administrative or trade-specific work was provided during the legislative committee update. Strategic item 2.2 reads as follows. Research the scope of unlicensed practice, evaluate allocated enforcement resources, and meet with industry stakeholders to review enforcement strategies. This item was summarized during the registrar's update earlier today, and then I will now move on to the next item unless there was questions on strategic item 2.1 and 2.2. And there's no questions here. Is there any public comment?
No public comment.
Okay, moving on to strategic plan item 2.3. That reads as follows. Coordinate educational workshops with agency partners to assist applicants and licensees in complying with contractor state license law and other business requirements. For this item, an educational workshop is scheduled at CSLB headquarters for September 11th, 2023, and an educational workshop is scheduled for Southern California, September 18th. We have committed from the Chief of Labor Enforcement Task Force for LETF to participate in these workshops. We do need to secure a Southern California meeting site still. And myself and the register folk were talking earlier, there could be a couple sites that become available, but if there's any additional ones, please reach out to CSLB. Moving on to strategic item 2.4. That item reads, review and create a structured enforcement training program with Enforcement Academy to achieve statewide investigation and legal action consistency. Prior to the COVID-19 pandemic, Enforcement Regulatory conducted 1-week enforcement academies. I'm pleased to report that 2 enforcement academies are currently scheduled, one for Northern and one for the Central region, as well as another one for the Southern regional staff. Both academies will be conducted by our Deputy Attorney General liaisons, Brent Jex and Christine Lee. The Northern and Central Enforcement Academy will take place July 17th through the 21st in Sacramento at CSLB headquarters. And the Southern Enforcement Academy will take place October 16th through the 20th in Norwalk. The Academy will provide an overview of the Department of Consumer Affairs and the CSLB's Enforcement Division's organization, the unit functions, the responsibilities, as well as an overview of the Attorney General's office and administrative processes. Topics to be covered include an introduction to investigations, interview techniques, report writing, safety awareness, phone tactics, specific code training, as well as practical exercises and individual assessments. Strategic Plan Item 2.5, moving on, reads as follows. Research the need to establish a public works enforcement unit to perform outreach to awarding agencies and coordinate public works investigations with compliance groups and government entities to enforce CSLL requirements. An enforcement quality assurance unit was recreated in 2022 with 4 special investigators assigned to the quality assurance unit to perform public works investigations as part of their duty statement. And finally, Strategic Plan Item 2.6 reads as follows. Continue to enforce workers' compensation insurance requirements to protect consumers and workers and scrutinize licensees who self-certify they have no employees. This effort is ongoing, and I will discuss these strategies more in depth during Agenda Item 3 tomorrow. That completes the Enforcement Division Strategic Plan items. Are there any comments here in the room? Seeing none, is there any comments from board members online or public members online?
No public comment.
Okay, moving on. Moving on to Agenda Item F.2, Enforcement Program Statistical Update. The Enforcement Program Statistical Update begins on page 119 of your board packet. Your packet includes thorough information, and I will actually request Enforcement Chief Steve Grove to provide a couple highlights at this time.
Thank you, Chair Mark. I have 2 highlights of successful investigations which resulted in recent criminal convictions that I'd like to share with you, beginning on page 119 of your packet. The first case involves unlicensed contractor Adam Soares, who contracted with a consumer in January of 2020 to complete a residential remodel project for over $240,000. Consumer paid more than $220,000 to Soares prior to terminating him when she discovered that all of the subcontractors he hired were unlicensed. A CSLB investigator referred this case to the Stanislaus County District Attorney's Office for multiple misdemeanor and felony charges, including Business and Professions Code Sections 7028, contracting without a license, 7159.5A5, accepting money beyond the value of work performed, 7161B, misrepresentation to obtain a contract, and Penal Code Sections 484B, diversion of construction funds, 487, grand theft, 532, theft by false pretenses, and 506, embezzlement. On March 20th, 2023, Soares entered a plea of no contest to contracting without a license. He was sentenced to 10 days in jail, 1 year probation, and ordered to pay $283,000 in restitution to the consumer. The next highlight begins on page 120 of your packet. In 2017, licensed contractor Jonathan Bermudez, sole owner of Futuras Painting, contracted with a consumer to construct an accessory dwelling unit, or ADU, for $350,000. Bermudez requested an unlawful $105,000 down payment. Bermudez was paid over $200,000 before being terminated by the consumer for failing to obtain a building permit and excessive delays toward completing this project. A CSLB industry expert determined that there was no monetary value to the work performed, and it would cost approximately $17,500 just to restore the property to its pre-existing condition. The case was referred to the Alameda County District Attorney's Office for multiple misdemeanor and felony charges, including Penal Code Section 368, elder abuse, 487, grand theft, and 484B, diversion of construction funds. On April 28, 2023, Bermudez pled guilty to diversion of construction funds and agreed to pay $75,000 in restitution to the consumer due by September 25th, 2023. He was sentenced to 1 day in jail and given credit for time served. And that concludes my highlights.
All right, thank you. Any questions for Steve? Any questions from the public for Steve?
No public comment?
Okay, moving on, thank you. You will, turning back to page 119, you will note some staffing information. Enforcement supervisors and managers continue to prioritize filling vacancies. Currently, there are 21 vacant positions, which is an approximately 10% vacancy rate. Interviews have been conducted and candidates selected for 13 of these vacant positions. Turning to page 121 is complaint statistics. For the period of July 1st, 2022 to April 30th, 2023, more than 14,000 consumer filed complaints have been received, or more than 1,300 per month. If you compare the first 5 months of a calendar year with the first 5 months of 2023, you will find that consumer filed complaints average approximately 1,100 per month in 2022 and 1,300 per month in 2023. Or to put it this way, CSLB has received 1,000 more consumer complaints during the first 5 months of 2023 year over year to 2022. With current staffing levels, the optimal maximum enforcement division caseload is 4,635 pending complaints. And as of April 30th, 2023, the pending caseload was 5,363. A major contributor to this increased caseload continues to be the residential solar installation complaints and a small number of contractors that are receiving an excessive number of complaints. Solar complaints are currently averaging over 200 per month. Consumer service representatives, CSRs, and special investigators in the enforcement division are working very hard to keep up with this incoming complaints. The weighted monthly case closing average per special investigator and the centers remain steady at 9 closures per month, just shy of the closure goal of 10. CSRs assigned to 2 of the CSLB intake mediation centers have exceeded complaint handling expectations by mediating or resolving more than 20 complaints monthly. From July 2022 through April 2023, enforcement efforts have resulted in more than $25 million in restitution to financially injured parties. Another board goal is to approximately dispose all but 100 complaints within 207 days of receipt. As of April 30th, 2023, 308 complaints exceeded 270 days in age. Enforcement supervisors continue to work closely with their staff and provide guidance during monthly case reviews in an effort to reduce this backlog of age cases. Moving onward to page 122, CSLB sponsored arbitration and disciplinary action statistics. Let us know if you have any questions about those. So we'll give a pause for questions. Any questions so far from board members? Seeing none. Any questions from the public?
No public comment?
Okay, moving on. And finally, I'll brief you on the proactive enforcement that CSLB is doing, which is conducted by the 27 SWIFT team representatives. This information begins on page 124 of your board packets. From July 1st, 2022 to April 30th, 2023, SWIFT conducted 17 undercover sting operations across the state, participated in 257 sweep days, and responded to 818 leads. by the industry or the public. The investigators closed 2,694 cases as a result of the operations, with 741 cases resulting in an administrative or criminal legal action. Additionally, over 1,039 advisory notices were issued for relative minor violations. These results are very impressive, but even more so considering that the majority of the investigators assigned to the SWIFT unit have been redirected from normal enforcement duties. During that time period, they provided assistance to the victims affected by the 2022 winter storms at more than 50 local assistance centers and disaster recovery centers across the state. SWIFT is currently collaborating with the National Association of State Contractors Licensing Agencies, better known as NASCLA, to perform multi-state proactive enforcement. You should receive a NASCLA press release regarding these national operations in July. That concludes the enforcement program statistical update. This is information item only, no motions are needed. But is there any other board comments? See none. Is there any public comment?
No public comment.
Okay, thank you. So we're going to move the final agenda item is F3, which is an update on CSLB's Solar System Restitution Program. This begins on page 129 of your board packet and includes statistics through May 31st. The latest stats as of June 13th are: there has been 632 claims received, 320 claims approved, $4,047,224 approved for payment, with 37 pending claims. This program became operational in January of 2022 with a $5 million general fund allocation, which includes up to $1 million for CSLB administrative costs. Because of the effective implementation and monitoring of this program by CSLB staff, administrative costs were kept under $400,000, leaving an additional $600,000 to go towards payouts to consumers. The average claim payout is $12,581. 10 of these claims referred to CSLB-sponsored arbitration. On January 1st, 2023, CSLB staff had to cut off receiving any new claims as the fund balance was nearing depletion. There are approximately 37 claims in process, which are expected to deplete the balance of the fund. Unfortunately, more than 180 additional claims were received, but the victims were notified that unless additional funding is received by CSLB, their claim could not be processed. So, as you can see, this has been a very successful program that has benefited hundreds of California consumers who were victimized by unscrupulous solar contractors. I would just like to take a minute and recognize the hard work of our staff from both the enforcement and executive divisions, some full-time, some part-time, who volunteered for this assignment. Additionally, I would like to give a special thank you to the California Solar and Storage Association for their assistance with locating solar industry experts who assisted with our investigations. CSLB staff continues to discuss potential future solar recovery options with the CPUC, but nothing concrete has been yet established. The next board chair may want to establish a 2-person advisory committee to discuss the potential need for a further solar recovery fund. This concludes the enforcement program update. Is there any board comments? Is there any public comments?
No public comment?
I will just take Susan Granzillo.
I do have a comment, and I think I mentioned this last time when we went into some detail. There has to have been some energy and commitment from some organization, and we can see it was AB 137, to come up with $5 million for solar recipients who have been wronged. And it's hard to believe that that has completely shut off the discussions of renewing this or doing it again, because it was $5 million, and yet it is the bulk of the complaints we receive. So are there any other ways that we may act as a board to see if that can be reclaimed?
Yeah, can I just provide a little background how the fund came about? For about 4 years now, we've met regularly with the Public Utility Commission and what's now known as was Department of Business Oversight, DBO, and now the Department of Financial Protection and Innovation. I think I got that right. So we have these regular meetings, and the morning we have the state entities meet, and they're confidential. But the second part of the meeting, we would have the public come in. And so what happened is we had a whole lot of public coming in from Central California. We had the mayor of Hurleon and Parlier routinely at these meetings, and they had been harmed extremely bad. And these are a lot of agricultural workers, low-income people. And so it became known that they had been taken advantage of. At that time, it was a lot of PACE loans. They'd taken out loans for solar projects. Some of them didn't even have. They never even got the solar project. So with Martha Guzman Aceves was a PUC commissioner at the time, and she was really the champion of getting this fund. And she worked with the Dolores Huerta Foundation, and that's a foundation in Central California that helps low-income people. And Beth Zedek is down in Southern California, same type of thing. They have attorneys that will represent somebody for no charge. And so these groups all got together and realized we needed something to help these consumers who had been targeted for solar that they didn't understand what they were signing up for. You had examples of a home with solar panels over the entire home. You had somebody took out a $100,000 loan for this, thinking he's going to sell this energy back to the electricity company, and it doesn't work that way. You get some credit, but they're losing a lot of money. So that is what generated the $5 million. And we had a lot of accusations, a lot of contractors revoked, a lot of cases filed criminally against these contractors. In order to qualify for the fund, you had to have a contractor that we either had revoked the license, was unlicensed, or we were going to be revoking the license soon. We had an accusation that was being pursued. So where are we at now? Yeah, what happened with the fund is there's 4 contractors that left literally 100 or more, consumers financially harmed. One was up to almost like $1 million what we figured out, one contractor alone. So what do we do now? We're working still with the Public Utility Commission, and with the board's support, I think we need to further that dialogue. We need to see if there's a way to have some type of continuing funding until we have a little better handle on this industry, because it is unique in construction. I mean, I'll just preface this by saying most solar contractors, they do a great job. They're ethical, no problem. But there are some that what they're doing is they're getting this payment directly from the lenders. They have a business model, and that is to collect the payment and not do the work. And that is a problem still. So now our fund is depleted, and we need to look for another funding source, or there's going to be a lot of financially injured consumers in this that have been taken advantage of by a solar contractor. But that's a long answer to say we're going to work with the Public Utility Commission, see if we can come up with some strategies. Perhaps the next chair wants to appoint a 2-person board member advisory committee, come back to the board, see if you would support the proposals.
Thank you, Dave. And secondary comment, at our last board meeting, you mentioned PACE. We did approve the support. I'm not sure assembly bill number, but maybe Jaminski can help out. But throw you out there. But there was a support for any type of legislation to have a new type of PACE type funding loan. And maybe Dave has a comment on that.
Yeah, so we have worked closely with various consumer protection advocacy groups, and they were hopeful that there'd be a trailer bill. The initial $5 million was part of the governor's trailer bills, general fund money. And there was some hope that we might receive something similar through this cycle. But the feedback we're receiving is there is a budget deficit now, and it's unlikely that will materialize. Have you heard anything more recent, Mike?
No, and we have until July 1st to hear something. I don't know if Fauna is still on the line. She monitors every single trailer bill. She'll pop in if she is. Otherwise, there's nothing to report on those efforts.
Mike, I had a quick question. We thought about working with the lenders and holding them accountable for releasing funds to contractors that don't have licenses and haven't done work.
Yeah, absolutely. And we've had meetings recently. We've had a number of meetings with PACE providers, with also green lenders. And I will tell you, I won't name any names here, but it's really interesting talking to one of the larger PACE providers where they recognize that they would argue they're duped and that the contractor said they actually had installed the system and that's why they paid for it. But we're telling them, we got examples here where you paid the contractor in full. They don't have a system. And you're making them pay on their property taxes. They can't afford it. They're still paying their property tax bill. And the answer was at this point, they said, we don't even have like $10 to return to anybody. We can't help them. Then we had meetings with the green lenders. We talked to them and said, this is what I'm asking. I'm just asking, don't pay the contractor direct. Pay the homeowner. That way they can control the money. But they don't want to take that approach. That's not their business model. They want to continue to do it. They tell you that we're going to put in more oversight. We're going to make phone calls, make sure the work's done. Well, maybe you need to have someone drive out there then and look at it. Because as long as you're paying the contractors directly, you don't see that in other industries. You just don't. But in solar, when you're doing it, and there's a track record of the contractors not completing the jobs, the consumers have nowhere to go, especially with the PACE loans, because they're a priority loan. Now, I want to say that the PACE loans were more than 40% or about 50% of our consumer complaints 2-3 years ago. Today, there's a lot less. So DFPI, that's the other stage I mentioned earlier. They're doing a good job, I think, now regulating them. But a couple of the PACE providers left California. I think you heard that was why there's a need for a PACE funding. Because when we talk about our solar recovery fund, we didn't pay out for any bad PACE loans. So I will say this, what we did do is look and see what the contractor received on many of them, and we would pay out the balance as to what the project was worth. Say the contractor got paid $50,000 from a PACE loan, the job's only worth $30,000. The consumer then would be entitled to a payout of $20,000. We did that. But that doesn't mean they don't have a $100,000 PACE loan on their house. Some people have multiple PACE loans on their home, and there's really no relief for them today.
I will add a comment of enforcement as a whole. In the report, there's a lot of these complaints are from the same industry, and enforcement as a whole is trying to crack down on that. I think at what usually happens, unfortunately, there is a couple unscrupulous contractors that are taking advantage of consumers, and a lot of the complaints are coming from the same contractors. So I know Register Folk and Chief Grove, they have a plan of attack going forward. And in the end, we're consumer protection. We're trying to make sure that these particular individuals, and ideally that we would not need a particular team to go out there and looking for them, but it's out there. So I commend enforcement staff for everything that they are doing, and especially when they are actually being taken from their job duties to help the general public in emergency cases. That makes it our workload even harder. So appreciate that. With that concludes the Enforcement Committee report. Unless there's any public comment. Seeing, hearing no public comment, that concludes the report.
Okay, thank you, Michael. So we will now move on to the Licensing Committee update, and I'll turn this over to Licensing Committee Chair Jim Ruane.
Thank you, Chair Teichert. Good afternoon. I'm Jim Ruane, the Licensing Committee Chair, and I'm providing the Licensing Division update today. Also, Examination Manager Carol Gagnon is covering for the vacant Licensing Chief. Former Licensing Chief Fode Garagoslu retired June 1st. So our first item is update, review, discussion, and possible action of 2022-2024 Licensing and Testing Strategic Plan Objectives. Let's begin with the licensing and testing objectives on page 133. Item 1.1 is to assess barriers to licensure for women and minorities and create an outreach plan to community colleges and construction management programs, labor unions, and workforce development groups to increase licensee diversity and create a better understanding of applicants and licensees. Progress with this project is ongoing, with the Public Affairs Office championing the Executive Division's outreach goals for employee recruitment. You will hear about efforts to encourage women to consider a construction career from Chair Teichert tomorrow. Item 1.2 is to study and appraise existing and prospective reciprocity agreements to determine if they are needed, and if so, whether qualifying criteria for reciprocity agreements need to be updated or codified legislatively. Currently, California has reciprocity agreements with Nevada, Arizona, and Louisiana. Written reciprocity agreements were established between California and Nevada in 2001, between California and Arizona in 2004, and between California and Louisiana in 2018. For these agreements, waiver of the trade exam is subject to the following conditions. Number one, the applicant applies for a classification that appears in the reciprocal license classification list. Number two, the applicant has held an active license in good standing in the reciprocal state for no less than 5 of the previous 7 years. And number three, the applicant must submit a verification of licensure from the reciprocal state. Staff is constantly reviewing requests from other states regarding reciprocity and has noticed a big discrepancy between contractors coming to California versus those who leave. Our records show that in 2021 and 2022, we accepted 24 and 27 reciprocity requests from Nevada and Arizona and Louisiana. In contrast, we completed hundreds of license verification forms for other states, such as Florida, which we do not have a reciprocity agreement with. We received 2,150 requests for license verification in 2022 and through May 2023. It is anticipated the 2-person board member Reciprocity Advisory Committee comprised of David De La Torre and Miguel Galarza will meet next month to discuss pending reciprocity requests and how to ensure consumer protection. Carol, would you like to say something?
Certainly. In addition to researching reciprocity, we're also expanding our exam administration to 2 other states. Most of our licensees with out-of-state addresses are located in Nevada, Oregon, and Washington. And so we're going to expand testing for all 47 trades to PSI test centers in Las Vegas, Nevada, where half of you are now, and Wilsonville, Oregon, which is really close to Portland and only 3.5 hours south of Seattle. Now, Washington doesn't have a test center that's listed on the master contract for DCA under PSI. Expanding to new test centers, though, is going to reduce travel time for out-of-state licensees or candidates and make it easier for reciprocity candidates to access the law and business exam. So when they apply for reciprocity here, it's going to make it easier for them to take their exam in their home state. That's all I have, Jim, for this.
All right, thank you, Carol. Next is Strategic Plan 1.5, to partner with public affairs to streamline and eliminate jargon on CSLB licensing web pages, handouts, publications, and forms to reduce user confusion and processing times. This is an ongoing effort between public affairs and the licensing division to find inconsistencies or errors on the website and streamline issues like the location or ease of access to documents, such as the license application, and provide clear explanations of complicated licensing processes. Current projects include updating the website to provide clear information about what criminal convictions will and will not preclude licensure, as well as clear up some inconsistencies in guidance for licensees who seek to change their license entity type with the Secretary of State. That completes the licensing division's strategic plan items. Do board members have any comments or questions? Are there any comments from the public there in the room?
Hey, Jim, this is Mary Tykert. I just want
Mary.
to appreciate and commend the data gathering effort that's gotten started. We're trying to understand the demographics of our existing licensees, because I think that's a good first step to doing anything that we want to have be different, is understanding what we currently have. So I really appreciate that effort.
Great. Any comments from the public there in the room? Rico, please check to see if there are any comments from members of the public on WebEx.
No public comment.
All right, thank you. Item number 2, licensing and testing program update and statistical summary. You can find the licensing update on page 138. I will highlight a few items for the board. Regarding applications, the packet on page 139 indicates the number of applications received. As you can see, the number for the last quarter is greater than the last 3 quarters. Licensing received over 1,200 more applications in the last quarter than it had averaged in the 3 quarters before. Also on page 140, you will see the processing time for all application types. Currently, processing times are between 3 and 4 weeks. Those numbers increased during the first quarter of 2023 due to vacancies, which resulted from retirements and promotions. The goal is to drop all processing times below 3 weeks and maintain this level. As of Friday, June 16th, the exam applications processing times are below 3 weeks. This means that a licensing technician will review the application within 3 weeks of it arriving at CSLB. I want to acknowledge staff's hard work for reducing processing times in pulling records over the last 9 years. Examination application processing times have only hit 3 weeks twice. The average over those years is closer to 5 weeks. Staff did a great job on this. Thank you very much.